workshop's being put on by the Business Leap Project, which is the entrepreneurship facilitator service that's funded by the federal government Department of Education, Skills and Employment. And we're funded to help people start and grow small business. So what we've had a bit of a call for is, how do people start to put on their first employee? What do they need to know? And just the HR essentials. So we have had a fair few people register so they could get the recording, because the time didn't work particularly well for them, but they are interested in the content. And what we've done is we've got Hellen Ryan from HR Solutions for You. Is that's correct?
Solutions for Human Resources. Okay, so obviously just the disclaimer first is that this is general and not specific, and I'm not offering any legal or tax advice. And this, feel free to take notes, and I've got a PDF of this presentation that we can send out if you want it. There's some handy links I've kept in the presentation. So let's start with hiring employees. So before you hire an employee, besides the recruitment and selection component of hiring the person with the right skills and the right ability to fit your team, just going straight into the mechanics of getting them on the books. So do they firstly have the legal right to work in Australia? So without being racist or discriminatory, anyone with an accent, I would check their status to work in Australia. So check whether they're a permanent resident, whether they've got an Australian birth certificate, or if they're a New Zealander, that's acceptable as well. They don't need any special visas. But when in doubt, check their visa, or if they've got a document to present to say they can legally work in Australia. And there's some links to visas and things like that. And that's a constant changing arena. So check whether they're an employee or a contractor. So Benita, you're very aware of this, being a contractor in the past as a sole trader. So an employee is essentially someone who's engaged in an employment contract for, and a contractor is someone who's running their own organisation and providing services or products to you and or other clients. We'll go through a little bit later with the crossover between an employer and a contractor, and what things an employer can be liable for, even though you feel you're engaging a contractor in their own right. It's very important to actually gauge the difference between that if you're engaging contractors to your business. You need to get some superannuation fund details for an employee, and before we used to have a default fund until just recently. Now you actually need to find the employee's prior superannuation fund. Even if they don't have the details to give to you, you need to contact the ATO and find out their stapled fund. And from my understanding, it's the most recent fund that they were an employer had been contributing to. So it's very important that you don't just dump funds into a default super fund. You do as much as you can to find out the information off the employee. If they don't have the information or are really slack getting that through to you, you need to contact the ATO. And personally, I've not done that. It's only a very new process. Also, with payroll, it's very important that you get a compliant payroll system that marries up with SuperStream, and that's a default setup where it extracts information from your payroll system and sends it to the ATO and sends information to the superannuation funds. And to be honest, it takes a lot of stress out of your role if you actually get a really compliant product, mainstream product, something like Xero or MyOb, or one of the big products that are actually investigate and find out if they're SuperStream compliant and ATO compliant. That will save you a lot of manhandling and back end stuff, and your accountant can just dial in remotely and manage things back end. So currently it's 10% super. It's actually increasing on the 1st of July to 10.5% on top of what the employee's ordinary earnings are, ordinary time earnings, and that's without penalty rates and weekend penalties and things like that. So it's based on their base pay rate, and that's paid quarterly. I've set myself up Outlook calendar reminders so you don't miss them. Set up a work cover insurance policy. Every employer in Queensland must have workers' compensation insurance, and the vast majority of employers have a work cover policy. You can self-insure, but you need to be a very large employer, and it used to be that you'd have to have a couple of $1 million sitting aside in a reserve account just in case you had to insure yourself against an incident. Some industries have industry redundancy schemes, and more and more industries are actually getting included into those. Some contracting industries, I believe NDIS, some NDIS providers that are on the SHARDS award, Social Community Home Care, etc. award, are now actually party to portable long service and possibly industry redundancy schemes. So it's worth having a look into them. So the disability services sector and construction industries are the key ones that are off the top of my head, I could say, that are in portable long service. And so that essentially goes into an external fund that the employee can tap into because they've been identified as like a transient industry. Fringe benefit tax. So depending on how you're paying your staff and what's included in that payment, you may actually attract fringe benefit tax. I am not an accountant, but I'm just bringing this up to make you aware of it so you can actually ask more questions of the right people. So examples of typical fringe benefits are if you give an employee the use of a work car for private, sometimes even housing the work vehicle at someone's home is considered as a fringe benefit. Giving an employee a discounted loan, paying an employee's gym membership, providing entertainment by way of free tickets or concerts, reimbursing expenses incurred by the employee such as school fees, giving benefits under the salary sacrifice arrangement with the employee can also attract fringe benefits. And fringe benefit tax is 100% of the value of the item or service you've provided to them. So you're paying double. So it's always very important to be aware that you're not going to get stung if something's gone wrong and hasn't been managed. So definitely get your accountant, definitely check out the ATO. Things that aren't typically fringe benefits are salaries and wages, shares purchased under approved employee share acquisition schemes, employer contributions complying to complying superannuation funds, employment termination payments, payment of amounts of deeds and dividends, benefits provided to volunteers and contractors, and exempt benefits such as certain for some certain religious organisations. So always check with the ATO. It involves a self-assessment. Some of the FBT costs can be income tax deductible. Generally, you can claim GST credits, and there are also special provisions for not-for-profit organisations. But please always check your accountant and the ATO. But mainly brought that up so you're aware of things that could possibly be FBT, and you can probably choose to actually, the employee may have a better take-home income if you just increase their pay and you're not losing out instead of giving benefits that attract fringe benefits tax. Develop a letter of offer or an employment agreement. There is a Fair Work template. but honestly, I don't like the template. It's got some wording in there that implies when an employee reads it that they're going to have an annual pay increase. That's not always the case. And they're going to have a pay rise beyond what the award says. So I just don't like the wording of it. So I've got fairly healthy and robust ones that include more than the bare minimum. So you can put some how an employee should behave, complying with policies and procedures, put little sections of things that won't change, that the do's and don'ts of being an employee. Put some of that stuff in there, but only if it won't change. Don't put procedural stuff in, because you can't change it if you've got it in your letter of offer. Develop a position description, and that's really critical. And to be honest, if you're looking at doing anything with your employees, firstly, map out what the job's going to be before you even hire them, because you will hire a better applicant if you thoroughly map out what you need done out of that role. Not only the duties and responsibilities, but also include the selection criteria that you're going to be needing in an applicant. So not only qualifications, but personality, traits, skills and abilities, numeracy, literacy, etc., IT skills, and map out what programs and software you'll be needing. Then you go into recruiting and selecting your employees. Use your position description and advertise and select employees in relation to your position description. That way it keeps you on track and you're not blinded by someone's lovely personality and then you get to the end and you hire them and you go, I forgot to check if they had this or that or the other. It keeps you on track. And it also enables you to extract information out of a potential employee that if they're a bit shy or the interview's a bit of an artificial environment, you can help keep focused and extract that information and ask further questions. I always, when I'm interviewing, I always develop interview questions and I extract the content out of the position descriptions. That way I'm keeping on track and I'm keeping focused. And then if I'm interviewing people across different days, I can then go back and compare apples against apples. And that way I'm not having to be confused or flustered. It stands out to me very easily with who's got what score on what topic, and what my overall ratings were, and a summary of my thoughts at the end. So I can interview people over a series of weeks and I can compare them quite fairly and evenly. And, depending on the mood of the day, whether you like people that day and whether you're not in the mood for this, I just need a body, get me a body, it can then help you control the external factors with recruiting. Also, if you've got employees doing physical tasks or tasks that may actually be repetitive, it's a really good idea to undertake pre-employment medicals to get a baseline of where the employee is, but also to check them against the requirements of the position descriptions. In my position descriptions, I develop physical abilities and emotional abilities required for the job. So if you had to do workplace rehabilitation, you knew the tasks, you can send that to a physio or a rehab coordinator, and then you can actually get them back at work. But also then it helps you hire people that are physically capable to undertake the physical tasks of the job. So that's really worthwhile undertaking. And depending on which organisation, it may be $200-300. It's really worth the money spent. Then you offer the job. You issue the letter of offer and the employment agreement. Issue forms that you've got to collect information. So the bare minimum forms are your tax file number declaration form, and that's a link to it. Superannuation standard choice form, and that you need back within 28 days ideally. If you don't have the fund or the employee doesn't know what the fund is, get them to fill out the form, everything except for the fund name, get them to sign everything, and then when that comes in, you can then add that information in. Issue the Fair Work information statements. That's a legal requirement, and I'll show you a little bit about that later. And collect bank account details so you can pay your wages. There's other information that I would usually collect, like next of kin, home contact details and things like that. But on these other forms of tax file declaration and standard storage form, you do collect that information. After someone's been employed, you need to keep a ton of records. And this is basically the makeup of your personnel files. Always lock or password protect if you've got it electronically, and make sure other employees and other people cannot access them unless they have a right to. So your payroll person or your HR person. So keep everything under lock and key because privacy laws are applicable. It is essential that you keep timesheets. Everyone must have a timesheet, even a managing director. By law, under the Fair Work Act, must keep a timesheet. The amount of Fair Work matters I've been involved in where people have been lovely people until things go south, and then all of a sudden I never took breaks. You made me work my breaks, which everyone knows that's not correct because everyone eats. And so having to prove that, the only way you can prove it is actually through timesheets, people clocking on for work and then clocking off for their meal break or their medical appointments or their kids' soccer or whatever, and then coming back and clocking back on. It's very important to keep timesheets. It's a legal requirement. Keep a copy of the person's resume and any applicable qualifications. Also, that then just gives you an overview to keep a spreadsheet on any expiry dates if qualifications expire, like first aid, CPR, any certifications that expire. Keep copies of pre-employment medical assessments in there, and that's a good reason to lock your files. The signed letter of offer and employment agreement, the signed position description, the signed superannuation choice form, confidentiality agreement. I actually issue everyone a confidentiality agreement when I sign them up. Every business has confidential information, even if they're not dealing with client information. It's information about your business, what your income is, who your clients are, things like that. It's commercially sensitive and it's commercially valuable. Keep it confidential. Signed policy and procedures, keep copies of them, whether they're in a folder or electronic format. You need evidence from a HR perspective to prove that you've been a good employer and you've given them an outline of policies and procedures and safe work method statements and all these sort of things, and how you expect people and require people to work safely and confidentially and within your business bounds. Keep a copy of part-time hours agreements if you've got part-time staff. That's another world of hurt in itself. So wherever you can, if you need flexible working arrangements with your staff, if you need flexibility in when they start and finish and the days that they work, I strongly discourage you from making it part-time. Some awards allow for flexible part-timers, most don't. It's mainly the hospitality industry awards. Copy of any working visa if that's applicable. Leave application forms, keep copies of all them. Fringe benefits information. Medical and sick leave certificates and any salary sacrifice agreements. There's probably a ton more other information you can keep, but keep as much information relating to specific employees as you can. It's all very valuable, but keep it confidential and private. Okay, then you need to induct your employee into the workplace, basic safety training. So that's the main reason the law requires us to induct employees into the workplace. It's about identifying safety hazards or safety concerns in the workplace and how to counteract that, how to minimise those hazards by doing special things that make that hazard more safe. But it is a legal requirement under the fire safety regulations to do fire evacuation training, fire extinguisher training, fire hose training. You can actually do that online. You can do it. There's organisations that do it online, but there are YouTube videos also that are very helpful that show you how to operate an extinguisher, and they're free. And I include those in my induction handbooks for staff. So when you're skimming through the handbook with the employee on the first day, you can stop and click the link and make sure they've viewed that. Also, safety policies and procedures and general do's and don'ts about employment. So I know we all focus on what we want out of the employee and meeting people and things like that. That's all very important to the operations of the business, but really you must cover safety stuff in your induction. That is the legal reason why we've got to have it. The business operation reasons why we have induction is so people hit the ground running, feel more settled in sooner, and they're more productive sooner, and they're complying with what expectations you have out of your employees. Then after they're on the job, we need to manage their performance. I strongly recommend a performance appraisal process, particularly during the probationary period. And I would do the most performance appraisals in your probationary period. Most employers are small employers, and small employers are calibrated by less than 15 employees. You have an automatic 12-month probationary period. Please do not shorten this. If you shorten it, you're shooting yourself in the foot. Everyone can behave themselves for 3 months. It's very hard for 6 months. It's almost impossible for 12 months. So please use the 12-month probationary period for as long as you can until your staff numbers get higher. And continue regular performance appraisals throughout employment, and ideally managers and supervisors should be giving feedback all the time. Hey, thanks for that, great job on this. Hey, can you do this differently? Can you do that instead of this? That's ongoing and constant. That's just part of being a manager or supervisor. But it's always a very good practice to keep a couple of them documented, and I've developed over the years a fantastic performance appraisal tool that is a tick and flick mostly with a few words, and it's a once every 6 months, or even more frequently if you want, but at least every 6 months to go through all aspects of an employee's work and their performance. So it's a great tool to then not only talk about the positives, but also talk about the negatives in a coaching way. It then gives you the opportunity to adjust and correct behaviours without making it a warning or a counselling meeting. And it's more of a motivational tool, and people are more likely to walk away from an appraisal with a few tips and tricks on how to make things better next time. Unfortunately, sometimes we've got to give warnings and terminations, and they must be procedurally fair. And if you're looking like termination could result out of a discussion you're planning on having, you actually have an obligation to allow the person to invite a support person. I offer that, and if they choose not to, at least then you can document on your notes that you've offered it. You can't actually prevent someone from bringing a support person to a discussion that is most likely or potentially resulting in a termination meeting. But the role of the support person is really not there to advocate. It's really a hand holder and someone to hand over the tissues and pat them on the back saying they're there. That is really the role of the support person. It's not there to talk on their behalf or to advocate on their behalf. Some people can choose to bring a union rep or a lawyer in, but in reality, they're wasting their time and money because they really are not there to advocate. It's not the place or forum for that. Also, you need to manage team morale, keep the team motivated and engaged, and getting the best bang for your wages buck. Keeping records also on how you manage your performance of your staff. Okay, then we've got workplace health and safety, work cover and injury management. So We have a return to work process, and so rehabilitation and getting people back into the workplace as soon as possible. There is a lot of help around that can help that, and thankfully WorkCover have really changed over the years. They've actually tee small employers up with rehabilitation coordinators, which is great. So it helps expedite the return to work on lighter or alternate duties. If also someone makes a claim for WorkCover, and the fashionable claim at the moment is, after I've performance managed you, oh, I'm sick tomorrow, I'm not coming in, oh, I'm bullied, and then all of a sudden there's a bullying claim through WorkCover. Please contest it. Not everything that's done that the employee dislikes is bullying. So please get help as soon as possible, and contest the claim if you don't feel it's credible. And even if it's a claim that you, another type of claim, please contest it and state the reasons why. But be very aware that the information can be accessible by the employee, so keep it factual, concise, and valid, and not opinionated. Risk assessments. We need to also assess the risks of all plant and equipment that we operate in the workplace, and we need to keep a record of that. We also need to assess the chemicals we keep in the workplace and the tasks. So a simple risk assessment tick and flick sheet is a great way to do that. Also, you need to identify hazards, record and fix hazards in the workplace, and keep records of them. So an accident incident report form, and also use that form. I amalgamate it with a follow-up form and just make it one form. You don't need less of them, to document what you did to close out or to minimise or reduce the hazard immediately, and also what your next steps are to minimise the hazard long term. That's pretty critical to capture that. And also maintain a chemical register and other applicable workplace health and safety registers for your industry. So, employees working from home. It's more and more the trend now that with the decentralisation through COVID, particularly city people have been more affected by people working from home. But in the regions, a lot of people work from home anyhow. That's just part of the advantages and disadvantages of being a small employer. You can work from home, and your employee can sometimes work from home. So the key challenges are supervision, motivation, communication, safety, feeling disconnected with the team. So this is a few things that you need to have procedures and clarity on, and sometimes it evolves as you go. You need to have a clear policy and procedure that working from home is a temporary thing, and that it can be changed at any time with a bit of notice with the employer, and that the employee may have to be required to return to the standard workplace. It's very important to make it clear that that is the case, so they're not just stuck at home and doing what they want. You need to still be able to manage them. I would encourage, if you're going to start it, doing a trial period and make it as a temporary arrangement. Be clear about costs, who pays for things. You need to check your applicable award, employee award. If you've got internet and phone, what the costs are there, and when work is to be performed, and also that you need to be available during the normal working business hours. Just because you're working at home actually doesn't allow you now to multitask while you're at home, looking after kids, elderly parent, or whatever. If you're hired to work, you're hired to work. Just because you're doing a different location doesn't allow you to do whatever else you want in paid work time. So it's really important to limit distractions, so no multitasking with other responsibilities, particularly with younger children where they're high focus. And that's not meant to be discriminatory, it's meant to be providing value for the dollars, for the wages people getting. Unless approved in writing. There's people who can work from home and there's people who can't work from home, that can't be self-directed and can't be focused on tasks unless they're in an environment where it makes them feel pressured too. Also, you need to undertake regular home and office workplace inspections and using a checklist, whether the employer does that or the employee does a self-reporting. The same laws apply in the home workplace as traditional workplaces in relation to workplace health and safety and employment and awards and things like that. You need to supervise people working from home differently. Focus on the results instead of the inputs, but you need people to be honest about their record keeping and the working hours. So they still need to keep a timesheet. There are software packages that I'm aware of you can buy, that if you've got someone primarily working on a computer that does regular screenshots at certain and random intervals during the working day. Look, that's foolable as well, but I believe there are packages around. But in reality, I would never let an employee work from home unless they had the emotional capacity to manage their own abilities and own time and were very good with time management and weren't easily distracted. So that's just something that is on an individual basis because of their capacities. Also, if an employee, I've got clients who have employees that work flexibly from home because they have small kids, they are the primary carer, and they may be a child with a disability, and they're, having to manage and juggle both primary carer duties as well as work duties. And if they're part-time or casual, that can work out. However, the employees choosing to be wanting to work at midnight because it suits their flow of the household, you shouldn't have to pay midnight penalties for an employee to choose to work when it suits the employee, because you're providing work that you need done between Monday to Friday, 8 to 5, or whatever the typical business hours of your business are. If the flexibility can be allowed, and if you trust that employee, you can actually enter into workplace flexibility agreements. So it's solely for the benefit of the employee. However, it doesn't penalise the business owner and doesn't bind them to penalties and loadings for working late or public holidays or early or on weekends because the employee chooses to manage their time that way. But if you require them to work on a penalty time or day or hour, then that's a different story. But for typical standard work practices between Monday to Friday, typical work hours within the ordinary times frame of your award, I would strongly recommend developing a flexibility agreement with that employee so you're not stung with penalties down the track. Okay, employee attraction and retention. Regionally, we're suffering a lack of housing because the city people are deciding that they want to get out of the city because of COVID, and they didn't like lockdown and want a bit more space. And plus also more people are able to work remotely because of people adopting technology changes way faster than what would have happened pre-COVID. So limited accommodation is a huge thing for a lot of businesses regionally. I know here on the Fraser Coast that everyone's growing staff number-wise, but you can't get accommodation. So people, you've got the jobs, but you just don't have anywhere for the people to live. So that can be a barrier. This happened when I was working in Gladstone through the liquid natural gas boom, when they were building the gas plants off on Curtis Island. A lot of smaller businesses ended up buying houses and then rented rooms within the house to employees, or rented the house to employees. But you've got to be very aware that you don't cause yourself a fringe benefit tax problem, and that you are like a proper tenant landlord, but you can then at least secure accommodation, and then you can offer it for a certain period of time whilst they then source other accommodation to their preference. Low numbers of applicants. I bet everyone's nodding with this one, or low number of quality applicants. So I've noticed that recently when I advertise a job. Locally, people have done a job shift lately and they're not looking for another job. Try focusing your jobs in Melbourne and Sydney on Seek, and change it around and swap the location around. You've got a month to advertise. Just keep changing the location in your Seek ad, but specify that it's at the lovely Fraser Coast or whatever hinterland region, and sell the region equally as much as you're selling the job. It may be exactly what someone's looking for, especially when they can buy a house for $250,000 versus, 700,000 or $1 million, and be far ahead lifestyle. There has been a hospitality employee industry shortage. I won't go into that too much, but essentially with the close downs, they were hard hit. And their industries were shut down, the doors were shut, they weren't allowed to operate. So a lot of hospitality people have actually moved into aged care and support services and things like that. So we've lost a lot of them. However, you've got a potential groups of people like school kids, after school work, weekend work. You've got people wanting to do a gap year. You've got retirees who have probably done it all their life, and they might be, caravanning around Australia. Encourage those sort of people. You might have them short term, but you might actually get a high skill set instead of training everyone from scratch. And thankfully, the borders are now open, and that our backpacker and fruit picker industry are now starting to get back on track. But, in recent times, they've had to look at alternate labour sources as well. They're just on consulting, there's a whole heap of grants around. So if you needed help from accounting, HR, IT, and a number of other things, there are so many grants around. So please use these links and find a grant that may apply to your business and your circumstances. Also, there's also wages subsidies for new employees, school leavers, and there's also for people who have been out of work for a number of weeks. So I think it used to be 4 or 8 weeks. You can get up to $20,000 wages subsidy for the year for a new employee, which is pretty amazing, offsetting huge costs. So it makes it more appealing to train someone up if you've got the scope to train someone. Workplace health and safety, industrial manslaughter. In Queensland, we had our first case of that. So you can actually go to jail if someone dies in your workplace and you didn't do much to prevent it. And it's about being negligently causing the death of a worker, and you can go to jail for 20 years for an individual, or 100,000 penalty units for an employer or an organisation, and a penalty unit's currently 137,000. That'll go up on 1st of July. So you're looking at $13 million for an organisation if you can't take the organisation to jail. So it's huge. It's life destroying, let alone killing a poor person. And the first instance of that was in Gympie. A little business owner was taking a large generator off the back of a flatbed truck with a forklift. And as small businesses, you'll have this clunky old piece of equipment that you've been operating forever. It may not be compliant with modern standards. People probably haven't been trained, or if they have been trained, there's been no record of it. Net result, there was no training. The forklift wasn't rated for the weight of the generator being taken off the back of the truck. There was no written safety procedures, and the net result, someone dying, and the owner of the business got 5 years jail. It's pretty scary stuff, let alone someone dying. So please, workplace health and safety is vital for all businesses, not just your trades businesses, any business. Underpayment of wages theft. It's a huge thing. And it's a penalty, it's a crime. Like workplace health and safety law is criminal law now. This underpayment of wages and not paying correctly per the award is a criminal law. You will go to jail. There's penalties. It's huge. It's not just dealing with fair work these days. So in the Queensland Criminal Code, if you deliberately or intentionally do something that leads to an underpayment or non-payment of employee entitlements, it's a criminal offence. So underpaying or hours or underpaying for work, penalty rates, unreasonable deductions, so taking deductions out of their pays for stuff that shouldn't have been deducted, superannuation, not paying super, withholding entitlements, through intentionally misclassifying an employee under an award or the wrong award or wrong classification, sham contracting, we'll get into that a little bit later, and the misuse of an ABN, so telling everyone working for your business they've got to be a contractor and you've got to have your ABN, and we don't have any employees but you can't really work anywhere else. It's really blurring the lines between being an employee and it's a sham being a contractor. And authorised deductions that have not been applied for as agreed. Crime penalties, it's deliberately stealing from their workers and you can be sentenced up to 10 years in prison. And it must be shown that the employer has intentionally withheld the employee's entitlements with the intention to permanently deprive the worker of their proprietary. Underpayments brought on by an honest mistake or delay cannot attract criminal offences. So basically, if you identify that you've been paying someone wrong, let them know immediately and take action to correct that and back pay. How are wages recovered by employees? There's a number of avenues, through Fair Work, the ATO or the Queensland Industrial Magistrates Court. So depending on which court and which arena is where they go. But if an employee takes it to the police, there's no guarantees the wages will be recovered under that arena, but they can apply elsewhere. It involves a conciliation process and employees have 6 years to go back and claim for wages not paid 6 years prior, because that's the limitation of wages records. Superannuation, it's on the move. Last year, it moved from 9.5%. It was stuck on that for a number of years. It's currently 10% as of today, but as of the 1st of July this year, it'll go to 10.5%. Please put an Outlook reminder on your calendar to make sure you adjust pay rates on the 1st of July and also superannuation rates and make sure they're applied in your payroll system. That's another good reason to make sure that you have a really good system like Xero or Myable. One of the big mainstream software packages that do a lot of this and help this out with you, and your accountant can dial in back end and tweak things. So the 2020 versions of the award, the awards were modernised in 2010. In 2020, they were being reviewed. They have a review every 5 years, but a lot of them are becoming 2020 versions. There's been huge changes in the last 2 years, which has driven me crazy, because not only have we had to deal with the panic and stress of COVID, we've had to deal with ongoing award changes and law changes and industrial relations changes. It's just been horrendous and fatiguing, but thankfully it's settling down and the changes aren't happening so quickly. So with the awards being updated over the last 18 months, 2 years, they've been changing a lot of the clause numbering. So if you're like me and you refer to clause number XYZ in the award in your letter of offer, and the award version's changed, it's got those all out of whack. They're trying to simplify the award language. I don't think they're quite there yet. And they're standardising some clauses across many awards. And also they've inserted new casual conversion clauses. We'll get into that shortly. So if you've got a letter of offer for current staff and it refers to the 2010 award, I recommend now communicating just in writing as an email or a memo to your employees, and keep a copy on their personal file that the award is now a 2020 version, and that is the award that now applies and covers them. Last year, 1st of July, there was an award increase of 2.5% and staggered rollout for that increase depending on which industry you're in. Most awards on the 1st of the 7th had their pay increase, award minimum movement increase. 1st of the 9th, the retail industry award was moved, and the 1st of the 11th. All the main industries hardest affected by the COVID shutdowns were then moved. Now let's move to now, what's happening now as of the 1st of the 7th. And this information had only just surfaced yesterday. The Fair Work brought this down of a 5.2% award increase on the minimum, the Fair Work minimum award, minimum amount. That's separate to the award amount. The awards had increased 4.6%. So if you had an employee that wasn't covered by any particular award, their pay went up 5.2%. If they're on an award, it's gone up 4.6%. And the rollout for that this year is the majority of awards are increasing effective 1st of the 7th, so we're only a few weeks away. And then you've got a handful of awards who are still having ongoing effects by COVID shutdowns and slow return after COVID. These are a list of awards are then changing on the 1st of the 10th. Fair Work Casual Information Sheet. Just stepping back a bit, it is a requirement that you actually include a Fair Work information statement with every letter of offer you give your employees. There's a standard one and then there's a casual one. For casuals, you give both the casual and the standard one. For everyone else, they just get the standard one. And you can easily find that if you just type in Fair Work information statement, and you should be able to get the latest one. They change every year. I'm not sure whether the casual one will, but I'll be updating mine just to be sure. So it's all the new information under the Fair Work Act about the changes in casual employment. We'll get into that. So most modern awards have been changed to reflect the new Fair Work Act casual changes. So casuals now may ask a manager or the owner to consider them making them part-time or full-time after a period of time. So typically it's after 12 months in most awards. Some awards say 6 months. So please read that section of your award. Employers must consider the previous 6 months work history, even if they've been employed for 12 months, and see if that history is likely to be considered as something that will continue into the future. And if over the last 6 months it's been regular and systematic pattern of hours or full-time hours, and whether that's going to continue in the future, whether the business needs for that amount of work and that style of work is going to continue. Sometimes people are employed as a casual for seasonal purposes only. Sometimes just for project only. So obviously their business need won't continue down the track. And also just because an employee is being considered for part-time or full-time, there is no guarantee that that will result. But you can't reasonably deny it if you meet those tests. And it's going to be regular, systematic. The business need would continue. And it's likely to be expected to work those patterns. You actually have to consider that. However, Mike, I caution you with part-time employees, depending on your award, many awards have very rigorous, very scripted arrangements around part-time employees. Not all awards, but many do. So that an example of that would be if you vary your starting and finish times, that's not acceptable. So really this part-time concept has been built around the working mum with kids in primary school who need to be picked up at 3 and dropped off at 8:30 or whatever, and you can't ask them to work overtime outside of that unless you're any extra outside of that, unless it's actually paid as overtime. So even if they're only doing 20 hours a week, if you get a part-time employee in some awards to work beyond their regular regimented hours, you'll have to pay overtime penalties, even though it's nowhere near the 38 hours a week. That's a big caution. Also, you can't chop and change their days a week and their starting and finishing times so readily. Some awards you can, but most you can't. So I caution people on part-time employees. Pre-federal awards, under state awards, you actually could have flexibility in their part-time employees, but not under the federal awards in many awards. There are exceptions with this casual conversion for smaller employees. If you've got less than 15 employees, you have to consider if they request it, but you don't have to go through as much process. Larger employers are bound by a rigorous process. So depending on their award, after the employee's been there 12 months, you actually have to communicate with them saying, hey, you've been here 12 months, we're reviewing whether you could be part-time or full-time, and we'll get back to you on that. And then you actually have to have a series of letters and do a bit of correspondence that way. It's quite onerous actually, and just what businesses don't need. But small employers have less rigor around that. So check your casual award clauses. So that's a link to the list of awards, so you can check out your specific award. And be careful if you print your award. By the time you print it, it's probably out of date. I like paper. I like printing an award and I like writing all over it. But when I read it, please always double check against the current version online. Stuff changes so quickly and it's not readily communicated. Independent contractor changes. So as of February this year, the law has changed around independent contractors. So depending on the contract, the company status, whether it's of the contractor, whether they're a company, trust, partnership or sole trader, or if they're selling a product, service or labour hire, the client business may be liable for workers' compensation, payroll tax and superannuation. So it's a bit frightening. You think you've engaged a contractor, so you've just got a one-off fee, but you actually may be liable for these other things. And more so in modern times, with the smart payroll systems, they're automatically communicating information at the end of every pay run to the ATO and to superannuation. And now behind the scenes, these bodies are now sharing information. They never shared it in the past. So government organisations are sharing information behind the scenes with tax and work cover and super. So please get yourself a good compliant payroll system and accounting system to help you manage. It just gets so much easier for you to manage all this back of house staff. So with independent contractors, the main change is that it's most risky to hire sole traders, partnerships, trusts that provide labour and are not registered as labour hire organisations. There's a special registration you need to be doing with that. So it's not enough to have a contract or an ABN to guarantee the client business that you're not going to be up for workers' comp, payroll tax or super. It is less risky to do business with companies like a proprietary limited or a business which is registered as labour hire, or if you're actually providing a product. There's a lot of law around this. You may need to talk to your lawyer. Not all lawyers are aware of this, and it's like HR. Not all lawyers are aware of HR law. So please find someone. I'm happy to talk to you and share a bit of my knowledge. I am not a lawyer, but this information is very valuable for you when you're hiring independent contractors. Check their ABN, check their company status. Consider whether they're supplying a product. If they're supplying their labour or someone else's labour, make sure they're registered as a labour hire business. Get evidence of it. So your single touch payroll systems really help out with this, but it also dobs you in if you're not being diligent back end with this sort of stuff. So the sham law. This is a law that prevents an organisation saying, hey, we don't want employees, we don't want to pay super, we don't want payroll tax, we don't want any of the hassles with having employees. So everyone needs an ABN and we're going to hire you as contractors. That's the sham. So there are huge fines for businesses that do that. It is not an easy out. It's actually a very expensive problem. I met a gentleman who actually got fined, and it's per each employee. He had about $400,000 worth of fines to the business because he had everyone as contractors. It's a sham. Just don't get tied up into that. If they're an employee, they're an employee. Treat them as an employee. Cater for it. Cost your goods and services to cater for the wages and the on costs. So I probably rushed through that, and I'm sorry, guys. So feel free to take down my details if you want some more information or want to have a chat about your specific circumstances. But I'll just stop sharing the screen now, if that's okay. And I'll just hand back to Brooke, I suppose.
I remember there used to be a threshold that if you didn't get X, even if you were set up as a proper contractor and the rest of it with your ABN and all your insurances and that, is there a threshold or has that gone? So I thought
I believe that's like gone.
80% of your, it used to be if you had more than 80% from one source, one client source, you were then deemed an employee, whether you liked it or not. Or is that gone, or is that
nothing's come up out? I attended a law seminar with an absolute brilliant guy who's actually an accountant and a barrister, and he's all over the employment law information, and I spent half a day with him going through all this, and that wasn't even brought up. So that's no longer a calibrating factor. However, I would still encourage people that if they've got contractors and they're only working for you, to really think twice about whether they're an employee. It wasn't something that was broached in that training, but the main defining factors are the contract and the structure of the entity providing the goods, services or product. So it's the company structure has a huge thing to play. So just having an ABM is not big enough and good enough. Being a sole trader is probably your most risky. Being in, so registering as a proper company, proprietary limited company, offers a big barrier for comeback. So, however, it may suit the business to actually have sole traders and deal with them. However, think twice about whether they're providing a product or service, and make sure your contracts are actually worded appropriately. I've got some model clauses that this lawyer gave me to put in contracts. So, but I can also give you his details. He's not cheap, but it's well worth it. So, yeah, and he said lawyers, don't go to your general practitioner lawyer. You need to know a contract lawyer who deals with that sort of stuff. So, if you're going to a mum and dad lawyer that just does wills and estates and occasionally dabbles in this and that, they're not going to know this information.
And do you have? How does it? So we do have some business lead clients that are setting themselves up as support workers to then contract into different support coordinators. Now, how does it work if they only have the one support coordinator? That's all they can get at that point. Is that and is the onus on the person that set themselves up as a sole trader, or is the onus more on the person hiring them?
Look, I can't really comment, but my personal opinion, and it's not a lawyer's opinion, protect the business you're working for. So as in, if you own the business, you've got to protect yourself. So the onus would be on you doing your due diligence, making sure either they're packaging whatever they're selling their services to you as a product, and it's a key word, as a product, and instead of a service, or costing out wages per hire, and making sure invoices are done that is a product, not by the hour. So different for me, I actually charge clients by the hour. However, I'm a proprietary limited business, and I'm not a sham employee because I've got hundreds of clients, and I offer, I give an agreement, a contract agreement, to letting them know my terms and conditions. So even if they don't have a contract with me, I give them a contract consultancy agreement to let them know, I invoice, I'm standalone and things like that. So yeah, so classic example would be, okay, well, how do you know about the plumber coming to your business site? He may be a sole trader. I've got a friend who's a plumber who's a sole trader. He's been doing it for close to 50, 60 years. However, he's not an employee in any capacity, because he comes in and fixes the tap and goes. He's not charging you at a labour rate, he's charging you for a finished product. So, that's a different story, like the electrician, the plumber, the tradie coming to your workplace to set stuff up. Different when someone's more part of your organisation, providing services that you're generating income out of. That's probably an alarm bell to start asking questions. And look, I'm happy to talk and share my limited knowledge. I'm not a lawyer, but I can at least give you a mindset of what I've discovered about these law changes, so you can then go do your due diligence and ask your lawyers on where to go next. I've crossed a broad selection of content that could apply to any and every business. Some it's applicable to certain industries, but I've tried to be as broad as I can. And each of those headings and topics are a huge bucket of information in itself. The key things to get right are, make sure someone's got the right to work with you, and ask a lot of questions if someone's a contractor. Ask how their company's structured. That's really important. Do you guys have subcontractors engaging services with you guys?
I do, yes.
Mm-hmm. Yep.
And I'm a little bit concerned that maybe it's not set up the way it should be.
Yeah, okay. So, yeah, well, we can certainly talk later, Benita. But, it does cost to set up a company. It's very low cost to operate as a sole trader. But if you're wanting protection for your business, you need to take action to protect your business in a way that you're not putting yourself at risk. You may choose to actually accept sole traders working for you, but please be aware and do due diligence and find out whether you need to account for their superannuation and payroll tax and things like that. So just be very aware of the costs and what you're willing to take on. Yeah. But in a nutshell, plan out your job before you hire someone. Make a really robust position description. And the position description's more than just do this, do that. So don't do it as a how to do the job. Just list their accountabilities and responsibilities, and any calibrating timeframes if you need to have that on there. But also, so once you also include any qualifications, license, certificates, or any prior experience that you really do need to have in a person applying for the job. Then when you develop a job ad, and in Seek it's brilliant, because it's the main platform that everyone goes on, but you can copy and paste whole sections out of your position description and just plonk into your Seek ad, so you're not inventing anything. And then when you actually select someone, you know, have some questions ready. Think out your questions. So develop these questions and use them every time you hire for that role. Look, manage by numbers. Don't rethink everything. So then if someone walks in, they're brilliant, and you weren't even thinking about hiring someone, but holy dooly, this person's too great to leave. I've got a list of questions for every jobs I held, I hired for in companies I worked for. I just do a quick printout, put their name on top, have a quick read of their resume, and then I can have an interview within minutes. So that really speeds you up. And you can evolve those questions over time. The beauty about standardizing interview questions, you can interview people across a series of days or weeks, and then you compare apples with apples. And if you've taken the same or similar notes and asked similar questions of similar people, it helps you then go back later on and compare the applicants, and you're doing it in the way that best suits the business. Then you've got your letter of offer. Oh, reference checking. Sorry, I've even forgot that. Reference checking is really important. I never hire anyone unless I reference check at least 2 past employers. And sometimes I check more. If I get a questionable response, I'll actually go and ask, you know, go and find out other employers they work for and question, just to put me at ease, or, you know, do I really want this person, or can I accept this flaw? And, you know, everyone's got flaws. Can I accept this? Can I manage it? Can I deal with it? Yep, okay, you can get them. So, and then the letter of offer and the employment agreement. As I mentioned, there is a standard template one you can get from Fair Work. It is lacking. It is really lacking. It's minimal compliant. Obviously, Fair Work's done it. There's a clause in there that says they got it, that a layperson reads, and it clearly, everyone who reads it says, oh, it sounds like I get a pay rise every year. It's not the case. You know, you don't need to state your pay will get reviewed with every award movement. You're going to do that anyhow. So yeah, sorry, am I missing some questions? So can you proactively approach prior companies without the person providing their details about reference checking? I will always ask for permission to reference check, and I do it I do it in the interview. And in reality, you're not wanting to spend your time and money reference checking people that you haven't first felt good with, you know, you haven't checked them out. So I only reference check those that I'm looking at hiring. That's probably the answer. And as one of my standard interview questions right towards the end of the interview is, you know, along with, hey, can you send me copies of your resume, your qualifications, your driver's license if it's applicable, and then the next question is, can I check with your current referees? Can I check with your past referees? And it's safer to ask that and tick it off when you're in the interview. Then you can't be sort of breaching someone's employment. Just recently, I held interviews with a very senior for an executive position. And I had 20 plus years experience lawyers, and I had very senior admin people and everyone in between. I asked them all, can I check with your current employers? Almost everyone said no, they don't want to risk their current employment. And can I check with your past referees? Absolutely. So if I really do need to check with the current employer because they've spent 20 years with them and they haven't worked anywhere else since, I'll go back and say, hey, look, we're about to offer you the job, but hey, we need to do our due diligence. I've checked with your past employer, but that really wasn't the same sort of job as that we're looking for. Your current employer, and I'll sweet talk them in, try everything I can to sweet talk them into it, and then get some background. Sometimes, as a least case scenario, I'll actually, and you might have people who have left the business who have supervised them, or at least been an equal as a senior manager. I'd probably then give them a ring as a bit of a, let's see how it goes. But that's not always the best way, because you want people who they've worked for. Look, I've got friends that I would never hire. I've got friends who are lovely people. They would interview really well, but I'd never hire them because they're slack asses. So, so you need an employer's perspective on the person's background. So.
For that. I did want to say thank you to everyone. Eden has made a recording of this. She will send it out to everyone so you've got the information, as well as I think Helen is saying that the slides will be available, so they will get sent out as well.